Thank you, Mr. Chair. Here in Congress, we have what I would describe as a anti-crypto derangement syndrome that clouds clear thinking about crypto regulation. Although there are too many myths to dispel, I will take the occasion to address a few of them. Myth, a statutory framework for crypto, would undermine 9 decades of securities law. Fact, the New York State Department of Financial Services has an alternate framework for regulating virtual assets. And far from undermining securities regulation, DFS has shown itself to be the most rigorous regulator of crypto in the world. Myth, there's no need at all for the SEC to provide regulatory clarity and guidance, and that calls for clarity and guidance are nothing more than a pretext for evading lawful compliance. Fact, even the Investor Advisory Committee, which favors Gary Gensler's approach to enforcement, concedes that there is in fact a need for regulatory clarity. Quote, the SEC should consider issuing a request for comment regarding areas where additional guidance is needed related to the application of federal securities laws to crypto assets. Myth, it does not matter at all if crypto is driven offshore. Fact, offshore, deregulated, over-leveraged companies like FTX carry the greatest risk of losing customer funds, a point that Gary Gensler himself did not dispute when pressed under questioning. Myth, registration with the SEC is just a form on a website. Fact, the notion of registration as just a form on a website is patently false. So false, in fact, that it would come as a shock to all the securities lawyers and companies spending millions of dollars on SEC registration and compliance. Myth, the SEC has the right to crack down on crypto because the technology has no utility. It does more harm than good. Fact, the SEC is statutorily designed to be a merit-neutral regulator. Even if SEC chair were as omniscient as God himself, he nonetheless has no statutory authority to impose his personal judgment about the merits of crypto and blockchain on those of us who disagree with him. The SEC's only role is to correct information asymmetries and mandate disclosures to protect investors. So my first question, one can imagine a digital asset that begins as a security, but then over time morphs into something else as it becomes decentralized. Ether, for example, was arguably a security at the time of the ICO, but then arguably became a commodity as it became decentralized. If a digital asset no longer has a central team from whose efforts investors expect to derive the profit, should there be a process by which that digital asset transitions from securities regulation to commodities regulation? Mr. Culkin, do you want to take a shot at that?
Congressman, so first, thank you for your remarks. I agree with your sentiment, and I think about these issues as being a former markets regulator. And so it's really not so much whether I think that there's merit to the product, but more that market participants need to be able to come in and know that the market has integrity, there's not fraud, there's not manipulation, activities being surveilled. In terms of transitioning from a security to a commodity, I mentioned this earlier, there's sort of the obvious 2 endpoints, a token being issued for a capital raise and something that's a good or an article that's relatively fungible. The point at which something transitions is really it's challenging to identify that specific inflection point. And so we can look at the different characteristics of the security.
You would agree that whatever regulatory framework we develop would have to delineate that process?
Absolutely, yes, sir.
But you have no clear sense of how that process should unfold?
It really depends on the facts and circumstances, and we've talked today about how these products and these markets are different than traditional debt or securities or equities, and so I'm reluctant to point out a clear, bright line here.
So we typically, maybe with the exception of stablecoin, which we think of as a currency in the strictest sense of the word, we typically think of digital assets as a binary, either a commodity or a security. Are those 2 categories exhaustive, or are there other categories that we should keep in mind? I see you waving your head, so that's...
Well, Congressman, first of all, something can be a commodity under our laws, such as Ether, by virtue of the fact that there is a futures contract traded on it. That doesn't necessarily mean it is not a security. You can have something that's both. And the question for a lot of these tokens is there still that enterprise behind it that is affecting its value. I'm not saying Ether is still a security, but I'm saying those questions still exist.
Yeah.
And yes, we need a transition. It's really a transition from when should all the securities laws that go to capital raising stop applying, because you really don't have an entity behind it, an enterprise behind it. We should have a process that addresses that.